All right, good morning, everyone. Thank you all for showing up, attending this morning's presentation. For those of you who don't know, my name is Justin Stivers. I'm the owner of the probate law firm. We do probate administration, estate planning, wills and trusts, office in Brickell, soon to be Coral Gables as well. But we practice throughout the state of Florida. And so the name of this seminar is Legacy Wealth Planning for Realtors, why most estate plans fail and what to do about it. So I teach this course a longer version of it. So I'm doing a condensed version of it. We'll probably, I'll try to wrap up around 35, 40 minutes or so, and then leave a couple minutes for questions. If at any time you guys have questions, just put them into the chat box, and I'll try to answer them as I go along. If it kind of is relevant at whatever topic I'm speaking about. If not, we'll save it for the end, and I'll try to answer them at the end as well. So this, the presentation that I do, which is a little bit longer, generally is just for public at large, people who are interested in doing an estate plan. And when I talk about an estate plan, I generally mean a will or a trust. But I'm trying to, for this specific presentation, I wanted to make it a little bit relevant. Obviously, you all are, could possibly need an estate plan or update your estate plan or something like that. So it's going to be relevant for just you personally. But I also want to tie it into you as realtors, how you can provide some additional value to your clients. Maybe some of these topics might be relevant for your buyers, for your sellers, and some things that you can talk about. Again, it's just kind of a value add to make you stand out from some of your competition by knowing some of these things. So I'm going to try to do both for your clients, but also for you individually as well. So, all right. So the kind of the theme, what I want you all to kind of maybe think about in the back of your mind, as we're going along, is if worst case scenario, if the worst thing happened to you tomorrow, right? What would happen to your family, your assets, and your legacy, right? So that's what I want you to kind of be thinking about throughout this. I know kind of a depressing topic a little bit, but if the worst thing happened, what would happen to your legacy, your assets, and your family? And so most people come to us when they've got 6 concerns. And that's when they start thinking about doing an estate plan. Number 1, they want to make sure that they pass on their hard-earned wealth without the government or the courts being involved, right? So they want to make sure that the money that they have, everything they've accumulated, goes to their family members or whoever they decide to leave things to, without it being, without the government or the courts being involved. Number 2, they want to pay, as little taxes and fees as possible. They want dignity in their final years and to avoid going broke through nursing home costs or other crushing medical expenses. So I think the average right now, annual nursing homes cost in the state of Florida is about $120,000 a year. So depending on how long you're in a nursing home, obviously that can completely deplete a person's savings or retirement funds. They want to make sure their family's protected from creditors, so people coming after them, or from predators, people taking advantage of their family members. Number 5, and maybe the most important, is they want to make sure that their family is not ripped apart through the probate process or through, just internal fighting after they've passed away. And then lastly, they want to find a way to capture maybe some of those intangible things. They want to pass on their values, their beliefs, their family stories, different things like that to future generations. They want to make sure that those things are passed down. So those are probably the six things that people, what I've kind of identified as like the 6 things most people come to us for, or why they start thinking about estate planning. So I'm sure some of those resonate with you all. But why don't people, actually do anything, right? I would say, I hear this all the time. I do a lot of, presentations or networking events, or I meet with people. And whenever I tell someone, hey, I'm an estate planning attorney, I do wills and trusts, almost everybody tells me, oh, I've been meaning to do that, or oh, I need to do that, or oh, I've got to get that done. I think it's one of those things that everybody knows, or at least believes, they should have it. They think they want to have it, but they just don't do it. So, and I think really two reasons. So the first is just procrastination, right? I just don't have the time, right? I just don't have time to get it done, which, could be a valid reason, right? Maybe, we're just busy and we don't put it on the calendar. And then the second reason is lack of knowledge or misinformation out there. And this is huge, right? There's so many. So on the other side, so we're talking about two different things. On the planning side is where I'm talking about doing the wills and doing the trusts. On the probate side is after someone's passed away. And I can't tell you how many times somebody will come to us either before or after the fact, and they just tell us something that's just not true. It's just not correct. And one of those things, probably the most common, which might shock a lot of you all, is that just by having a will, so if all you have is a will, a last will and testament, even if it was done by an attorney, even if you didn't just go to online site or pay $100 to get one done, if all you have is a will, your family's going to have to go through probate. So having a will actually does not avoid probate. And that's just a big misconception a lot of people don't know. So I think, the other reason people don't do anything is just because they don't have the right information. They think everything's going to be taken care of. And, unfortunately, they don't find out that it's, wasn't taken care of until it's too late. So what do most people do, right? So they either do nothing, right? They just say, hey, I'm going to get around to it. Like most people just, at some point, hey, I'll get it done. Or two, they do a cheap, DIY, do it yourself plan. So the do it. So let's talk about the do nothing plan. So on the asset side of things, if you do nothing, talking about those 6 major concerns, your wealth is going to have to go through probate. So if you do absolutely nothing, chances are, and let's talk about for you all as realtors, if you do nothing, if your clients do nothing and they own a piece of real estate, when they pass away, their property is more than likely going to have to go through probate, which means there's going to be a court involved, which means there's going to be a judge involved, which means there's going to be an attorney involved. And for those of you who have experienced the probate process, you've probably been frustrated by it, right? And so you've maybe wanted to sell a property, buy a property, or maybe you've been through it personally. And if there's a piece of real estate, most of the time, even if it was a relatively smooth process, it didn't happen overnight. Most of the time, it's going to take several months or longer, and there's a lot of stress involved. So if you do nothing, the government is going to be involved. The courts are going to be involved, and they're going to say what happens to your stuff. Now, that might be okay, right? That might not be a problem. If you want everything to go to your kids or equally to your children, then that might happen. But if you want to kind of, maybe you have a son who you don't get along with, and they've taken advantage of you, you don't want to leave anything to him, or maybe you don't have kids, and so now everything goes to your parents, and maybe that's not what you want. So you really don't have much say. Again, the court's going to say, what's going to happen to that. So that's the asset side of things. That's your house, that's your bank account, that's your medical expenses, or your bank accounts, everything you have. Courts are going to say what happens with that. But the other side of it is the medical side of things, which a lot of people don't think about. When people talk about estate planning, wills, and trusts, most of the time they're thinking about their house, their car, their money, things like that. They're not thinking about the medical thing. And that's another really key component about the estate planning process is when we're doing somebody's plan, we're going to do a bunch of documents that are going to say, who can make medical decisions for you if you're unable to, right? So if you're in the hospital, God forbid, and incapacitated, unable to make medical decisions for you, do you have a power of attorney? Do you have a healthcare surrogate? Do you have a living will? All of these, have you named somebody who can be your legal guardian if necessary? So all of those things are very important. And most people don't think about them, right? And unfortunately, I get this call multiple times a month where someone will call me and they'll say, hey, my mom, my dad, my husband, my spouse, they're in the hospital, or they've got Alzheimer's, or they've got dementia, and we need to sell their house, or we need to access their bank accounts because we're not on there. And unfortunately, at that point, when a person is incapacitated, when a person has Alzheimer's, when a person has dementia, we can't do anything. And so what happens then is now the family's got to go to court. The family has to ask the judge to name a legal guardian over the person. And that's the person, basically the court is going to take away a person's legal rights and give those rights to somebody else. And if you haven't named somebody who you want to, be your legal guardian, if necessary, the court most of the time is going to appoint an attorney or appoint somebody else. And that can cost a lot of money. That can eat up their money. And just from a, probably control aspect, that person probably would not have wanted a stranger becoming their legal guardian. One of the things that's this is a little kind of similar, but with the whole Britney Spears thing, right? She had a legal guardian. She was unable to make a lot of decisions on her behalf, and she had capacity, right? She knows what's going on. But when someone gets to the point of having dementia, Alzheimer's, and they don't, court's definitely going to step in and do something. So if you do nothing, that's one of the concerns. And I think that's, one of the really things that people don't think about. A lot of times people tell me, oh, I don't have any money. It doesn't matter. Just it doesn't matter what happens, but they don't think about the medical aspect of it. And then the one other thing that I'll mention is, if you've got kids, if you have children under the age of 18, if you have minors, what happens if both of the parents pass away? Who becomes the legal guardian? Again, if you don't have anything in writing, the courts are going to decide that for you. So, a little bit to scare you, but those are the things that can potentially happen. That's to do nothing, right? And that's what I would say probably 60% of the people do, 50% of people do. It's just they don't get around to it. They wait until they think, hey, now I'm too young. I'm in good health. I don't have any money. I'll wait till I get older. But then certain things happen and it just becomes too late for them to be able to do it. Again, not to scare people. But I've had so many clients that passed of COVID, right? I've had so many. And obviously they did not think that was going to happen to them. And now they were young. Many of them were young, healthy. And so now their families are having to go through the probate process. So that's the do nothing plan. The other thing that we see is just what I'll call cheap plans, do it yourself plans, right? And so you all are probably familiar. Maybe some of you even have them. It could be you went to a website like LegalZoom or Office Depot, or you downloaded a template online, or somebody gave you a template, or maybe you just went to, your bankruptcy attorney, your family law attorney who doesn't really do wills, but charged you $500 for it or something like that, and drafted a will. At least with doing nothing, you kind of know where you stand. The problem with cheap plans or just kind of bad plans, incorrect plans, is you don't really know that they're bad until something happens. It's kind of like having, bad insurance. You think you have insurance, you paid for it, and then when you need it, you realize it actually is terrible insurance and isn't going to cover what you thought it was going to cover. So that's what I'll spend the next little bit talking about, and to talk about why, when you do get around to doing a plan, or again, maybe when you're talking with your clients about the importance of having a plan in place, these are the things you need to be thinking about. So what most people don't, so these are just a couple things that people don't think about when they're doing their will, right? I would say 90% of people, most people, what they want is, when I die, I want everything go to my spouse. When my spouse dies, we want everything to go to our kids, or some variation of that, right? That's usually what most, you have the occasional person who wants to leave things to charities, or set up a foundation, or leave something to a brother, or, whatever. But most people, it's everything to my spouse, then everything to our kids, which is fine. But what happens so that's what most wills say, right? Most wills are just going to say everything to the spouse, then everything to the kids. And the husband and the wife, they each do their own will, and they say the same thing. When the wife dies, to the husband. When the husband dies, to the kids. When the wife dies, to the, so that's what most of them say. But what people don't think about is, what if you die and now your spouse remarries? So you've got a house, you've got money, you die, everything goes to your spouse. Great. That's what you wanted to happen. And truthfully, if this is your first spouse and you haven't been married before, you probably don't even have to do anything, because just by law, if everything was on title together, the house is going to go to him or her. The money, if you had bank accounts together, they still have access to it, which is fine. But now, what if that spouse, the one who's not passed away, what if he or she remarries? So now your surviving spouse has remarried somebody else. And now what if they get divorced? So you had a house with your spouse, you pass away, that goes to the surviving spouse, and now they remarry. Well, if that new husband and wife, if they get divorced, it's very likely that whatever you left and you had intended to go to your kids, 50% of that most likely is now going to go to that new spouse. And so a lot of people don't plan for that. A lot of people don't realize that, and they get remarried and then they get divorced. And now what the first spouse wanted to go to the kids, which was the original plan, now is going to go 50% to that new spouse. So that's why a basic will, a simple will, might not be good in that instances. Second, what if you have kids and they've got creditors, right? And again, everybody tells me, oh, but my fill in the blank, my kids, my spouse, that would never happen. It happens. I do about 400 to 500 probates every single year, and I see these things all the time. The kid has creditors. So the kids that you're leaving things to, maybe has a judgment against them. They got in an accident and they got sued. If you're here in South Florida, you know that happens all the time. A lot of people getting sued. So the kids have a judgment against them. The kids have credit card debt, something like that. And now you pass away and you leave them $50,000, $100,000, $500,000, whatever it is. That's going to be subject to creditors, right? Those creditors are potentially going to go after that. Could have been avoided, and we'll talk about how to avoid some of those things. What if the kids have substance abuse? If they've got drug and alcohol problems. If your simple will that you had done says everything to the kids, well, now you're leaving a house, money, whatever it is, outright to someone who's struggling with some sort of addiction. Probably not a good idea. What about if the kids get divorced? You want to leave everything to your kids. And this is, one of the most common things that I hear people concerned about when we start talking about this is they say, I don't really like my son-in-law, my daughter-in-law, or the person they're dating. I'm concerned about that. Happens all the time. You leave money to that kid. That kid's married. They get divorced. Now he or she's walking away with 50% of the inheritance that you had left to that child. Might want to plan for that. Tax benefits, again, if you just do a simple will, you're probably not going to be taking your kids are going to be exposed to possibly, paying high taxes. We talked about probate and how having a will is not going to avoid probate. So you just leave everything to the kids outright. And you all as realtors are going to see this if you're in the probate process. Someone dies, kids inherit the property. Now they got to go through probate. It's going to take 7 to 9 months. Stressful for everybody before they can sell it. Wouldn't it be nice if when mom and dad die, the kids take ownership that same day or the next day, and you can list the property the next day? Going to make everybody's lives a little bit easier. And then no protection from nursing home expenses if you just do a simple will. And so that's, we won't touch too much on that, but that's a big concern for a lot of people. So those are, again, that's the last little bit I'll scare you all with. But, how do we avoid those things, right? So how do we plan so that most of those things, all of those things don't happen? So what we do, what my office does, or if you're looking to do something, we do something what's called legacy wealth planning. And what we do is we start it with a trust, right? Or what we call a family wealth trust. And the way, the way I kind of think about it is, you know, it's a treasure chest, right? So the trust document is the treasure chest. And we want to put all of the assets inside of the trust, inside of that treasure chest, right? And that will fix a lot of those things that we just talked about. So what I mean by that is we can put language into the trust document that's going to say, if I die and my spouse remarries, that's fine. I don't care. I can't really control whether they do. Maybe you like it, maybe you don't care. But what I don't want to happen is the money that I've made, that me and my spouse have made together. I don't want that spouse to remarry and then they get divorced and then 50% of it be taken away from my kids. So what we can do, there's a couple different things, but one option is we could leave in our trust document that says, okay, if I die, my spouse can keep getting money from my accounts, can have the house, all that sort of stuff. But if they remarry, they have to get a prenuptial agreement before they remarry. And that prenuptial agreement is going to protect the assets that I have to make sure that they go to my kids, right? Instead of being subject to any sort of divorce. And this is, a powerful thing because some people, don't agree with prenups or feel uncomfortable or don't want to bring it up. And this way, you're kind of from the grave telling them that a prenup has to they can remarry. You can't tell them not to remarry, but the prenup is in place to protect your kids, essentially. So that's something that we can do with the trust. The creditors or the children with substance abuse, we can set it up so that before the kids get any of the money, before the kids receive anything, before the kids get any sort of inheritance, we can name somebody, a third party, to manage that money for the children for an indefinite amount of time, for a short amount of time, to make sure that we're not just giving whatever that amount is, $50,000, $100,000, to somebody, to a child who's got a bunch of judgments out there or has drug alcohol problems. And they're not just going to get that money and then it's going to be taken from them or going to be used, in ways that you probably wouldn't want it to be used. So we can set up a separate trust for those kids. And that way, you're protecting them, right? You're not, you want to make sure that they actually get the money, and you want to make sure that they actually are using money for things that you would agree with and are not going to be harmful and detrimental to them. So that's something that we can do. Same with the child who maybe is dating someone or married to someone that you don't like, or you're afraid about them getting divorced and them taking half of that money. We can set up a trust for them so that money that you're leaving to them essentially stays in that trust. It's only for that child. Right now, if they withdraw some of it, when they withdraw some of that money is potentially going to be subject to any divorce proceeding. But the money that stays in the trust, and we can set up some rules and parameters for that, the money that stays in that trust is very more than likely not going to be subject to any sort of divorce. Right? There's tax benefits by setting up the trust. And if done properly, and what I'll talk about now is it's going to avoid the probate process, which is a huge thing. So those are all, those are a lot of the benefits that come from setting up the trust, from setting it up properly and whatnot. Now, how do you actually do it, right? So how do you actually set up the trust? I talked about it being like a treasure chest where we have to put assets into it. And this is where, I see a lot of people make mistakes, a lot of the do it yourself stuff. Again, remember, the will isn't going to avoid probate. So if you've got a house at 123 Main Street and excuse me, and it's in your name only. So you, Chris, you, Christina, you own the property, it's in your name. You do a will and you say, I'm leaving it to my children. Well, when you pass away, your kids are going to, even if you have a will, your kids are going to have to go through probate in order to transfer the property into your name. So what we would do with the trust is we'd set up the trust document, which again, it's just a document like a will. It's going to say who gets what of your stuff. But if the property is in your name only, we're probably going to do what's called a quitclaim deed. And I'm sure you all are familiar with that. And you're going to transfer the property from you individually to the trust. And so now the trust owns the property. So for example, if I own a property, Justin Stivers owns 123 Main Street, and I now do a trust, and I've got the Justin Stivers Legacy Wealth Trust, or whatever I call it. I'm going to deed the property from myself individually, Justin Stivers, and I'm going to make the trust, the Justin Stivers Trust, the owner of the property. When I do that, now whoever in the trust, whoever I'm leaving the property to, when I pass away, they are going to essentially receive that property without having to go through probate. Chances are they're not going to have to hire an attorney. If they want to sell it, they could sell it, the next day. Makes it very, very simple, very easy for them, right? And so a lot of benefits to it. You're not going to lose the homestead exemption. And so most of you all are probably familiar with a homestead exemption. You get tax benefits and everything like that. By putting the property in the trust, you're not going to lose your homestead exemption. It's not really, for all intents and purposes, of transfer of ownership. Okay, so you're not going to get property taxes reassessed on it. And then again, you avoid the probate process. So that's a huge thing, but that's a step that a lot of people miss. And so if you're going to do a trust, or if you have a trust, if someone's drafted a trust for you, ask them or look at and make sure that the property you own actually is in the trust, that the trust owns the property, that a deed was done, that a deed was recorded. And so that's something that you could potentially talk about with your clients as an option, right? Because a lot of people just don't know this. And if the trust is already set up before they purchase the property, they can purchase the property in the name of the trust. So we'll have clients all the time who, maybe they didn't own a piece of real estate at the time. They owned a piece of property, or we did the trust for them for a variety of reasons, but they didn't own any real estate. When they go buy a piece of property, they're just going to tell the title company, the real estate attorney, the agent who's working on the file, hey, we've got the Stivers Trust, we've got the Mendez Trust, or whatever it is, and they'll just put the trust as the owner. You don't have to quit claim it or anything like that. So it's really simple. So if you're working with somebody, that might be something that you all talk about. Just say, hey, listen, have you thought about what happens with that property after you pass away? Do you want it to go to your kids? And here's one other point on that with children. A lot of times people will say, hey, I want to leave the property to my children equally, right? And so what they'll do, and maybe you all have seen this, is they'll do a deed. They'll do a life estate deed, an enhanced life estate deed, also known as a ladybird deed, which basically says, when I die, I want the property to go to this person or these two people, right, equally. And that serves a purpose. That avoids probate, right? If they're on title, if you have somebody who it's a life estate deed, a ladybird deed, and you've named these individuals on title, it will avoid probate. But what if you're leaving the property to two people? Or what if you have a will that says, I want my kids to get the property equal 50-50? Okay, sounds good. But what happens, and I'm sure somebody on here has had this happen to them, or at least heard stories, horror stories. What if brother and sister can't agree what to do with the property? Brother wants to sell it, sister wants to keep it. Brother wants to hire one realtor, sister wants to hire another realtor. Brother wants to rent it out, sister wants to live in it. So many different things. And if all you have, or all your client has, is a will that leaves the property equally to the kids, or you've done a life estate deed leaving the property equally between the two kids, that's it. Once that happens, those individuals own the property 50-50. And if they can't agree on what to do with it, and I can tell you most people do not, they will have to get the courts involved, and it's going to be a battle. It's a whole nother, won't go into it, but it's a whole nother lawsuit called a partition action, in which the judge is going to get involved and ultimately probably force the sale of the property. And now you've got kids fighting, and you've got attorney's fees and costs and all this sort of stuff. Even though the parents' goal was, nice, they wanted the kids to get everything equally, they didn't anticipate, their kids fighting. And again, one of those things, but it will never happen to me. My kids love each other. They get along. Well, they might, but when you die, the gloves come off and they see themselves getting a large amount of money or something like that, and it can get nasty. So what we can do in the trust is we can say, listen, when I die, I want my kids to get the property, but I don't think I'm gonna say that somebody, a third party, usually it could be a kid, but you might say a third party, I want them to order an appraisal on the property. I want them to give the children, once we know the value of the property, I'm going to give the kids 60 days. If one of them wants to buy the other one out for fair market value and they can get a loan on the property and do that, or pay it cash, whatever, great. If within 60 days they can't agree on what to do with it, I want this person to sell the property and then split the proceeds 50-50 between the kids. And that way you've got some control. Now the kids might not necessarily love that, but you've at least forced them to do something with the property, as opposed to having a litigation over the next 2 to 3 years because they can't agree on what to do with the property. So that's another really cool thing that you can do with the trust, which I generally advise most people to do when you're talking about leaving a property to somebody, because just putting multiple people on property can be really, really bad for most people. So we want to put the property into the trust, and then the other assets, right? So if you've got a bank account, if you've got investment accounts, stocks, bonds, usually most things, probably not an IRA or life insurance, depending on the situation. But other than those two things, most everything else we need to actually put into the trust. And the way we do that is we're going to, either name the accounts, kind of like how we named the property. We put the trust as the owner of the property. If you've got an account with Bank of America that's in Christina's name, we're probably going to put the account in the Christina's trust name, and we're going to name the trust as the beneficiary on all of the other accounts. And the reason we do that is so now when you pass away, your trustee, which is the person kind of in control of managing everything, has immediate access to that money and can go make distributions to the kids or to whoever you're leaving things to. And again, it's all about ease. It's all about just making it simple for your heirs, for your beneficiaries. And I can tell you, unfortunately, it's and hopefully not, but most of us have experienced or we will experience the passing of a loved one at some point in our lives. It's a very difficult situation. It's very emotional. There's a lot of things going on. You're dealing with funeral, cremation, the ceremony, wrapping up their affairs, going through their stuff, all these different things. Now throw into the mix, you have to sell real estate. You have to find their bank accounts. You have to hire an attorney. You have to go through probate. It's going to be 7 to 9 months. You're dealing with fighting people. Most people don't want that, right? Most people, if you've been through it, the value of making sure that it's easier for your family and your loved ones. And so that's where, kind of the misinformation about, hey, let me just do a real simple will. And that's good enough. And most of the time, it's probably not going to be good enough. So, those are, that's kind of what I wanted to talk about today with your clients. Again, so for you individually, maybe one of those points resonated that you don't want to pay extra taxes. You don't want your kids to pay taxes. You want them to avoid probate. You want to make sure you're protected from all your money going to nursing homes. You don't want to you've got kids and you don't like their spouse, or they've got drug, alcohol addiction. All those things, we can do that, for you. We can help you set up a trust. But for your clients, when you're speaking with them, I think it's worth a conversation to kind of talk about, how do you want to own this property? And because most people are not going to know, right? Most people, when they get a home, they have no clue what the deed is going to say. They have no clue what the title is going to say. They're just kind of leaning on the title company, leaning on the real estate attorney, the agent, to kind of just walk them through the process, and that's it. And I see a lot of things where, it doesn't have both spouses on the title. It just says John, a married man, but it doesn't have the wife on there, or some issue. And now, it creates a lot of headaches going forward. So if you can talk with them and kind of walk them through, hey, there's some things that maybe we can protect you from, some liabilities, some taxes, some tax benefits. If something were to happen to you, where would you want the property to go? These are all, I think, just, again, added values for you all to be more to, I think probably most of you all would agree that you want to be seen as the trusted advisor. You want to be as their go-to resource. You want that client coming to you for everything because they're going to sell that property in 7 years or buy another one or refer you to somebody, and you want to be that go-to. So these are ways that you can kind of cement yourself into that relationship even more, and be their go-to person. So I'll put my information into the chat box. Love for you all to reach out if you have any questions. Like I said, I'll send you this recording, but I haven't seen any questions come through, but I think you all can unmute yourself, or if you want to put something into the chat box. I've got another couple of minutes. I think we're right on time. So I'll stick around for a second, but if not, it's been fun. All right, I don't see anything. Easy group today. So I'll send you all a copy of the recording later today. And like I said, my email is just justin@probatefirm.com. Go to the website probatefirm.com. And if you all have any questions, I'd be happy to speak with you. Thank you again, Rochelle, for the invitation. And we'll talk to you all soon. Thank you all. Take care.